A prenuptial or pre-civil partnership agreement is an agreement entered into by spouses or civil partners in which they set out their intentions and wishes in relation to their respective finances and properties, and set out how they would like any issues to be dealt with on divorce, separation, dissolution, or annulment. The agreement can deal with properties, lump sums, and other assets including pensions, and can also set out any agreement in relation to maintenance or financial provision. Prenuptial and pre-civil partnership agreements are still not legally binding in England and Wales, and this means that even if you do enter into a written contract with your spouse or civil partner, the court can still overturn the agreement if they consider that the terms are unfair to either party. Although current legislation doesn't allow for prenuptial or pre-civil partnership agreements to be considered automatically binding, the court more and more recognises their importance and is now regularly prepared to endorse and uphold their terms in the event that they are challenged in court. Recent case law suggests that the court will uphold an agreement if the judge considers that it is fair. What is fair is ultimately decided by a judge and will be specific to each case, but in broad terms, the court is looking to ensure that each party's reasonable needs are met by the agreement. If the agreement is heavily weighted in favour of one or other party, and for example leaves the others struggling to house or support themselves, then it is unlikely to be considered fair by the court. A recent Law Commission report suggested that agreements would be upheld only after the parties' financial responsibility to any children and to each other was met, and I think this is something that it is useful to bear in mind. Within financial proceedings, the court has wide jurisdiction to make orders which deal with assets brought into the marriage by one party, business assets generated by one party, or inheritances received by one of the parties to the marriage or civil partnership. Many people may wish for certain assets owned by one party to be considered separately from the joint assets built up during the marriage, and a prenuptial or pre-civil partnership agreement can set out intentions for these assets as well as providing for the division of joint assets in the future. The Law Commission has issued certain guidance in relation to prenuptial and pre-separation agreements, and following this may give more weight to the agreements in the event of divorce or dissolution proceedings. Number 1, neither party to the agreement must have been under any pressure to sign the agreement. Number 2, each party should obtain independent legal advice. Number 3, the parties should exchange full and frank financial disclosure setting out their financial circumstances. Number 4, the agreement must be signed at least 21 days prior to any marriage or civil partnership ceremony. Number 5, the agreement should provide for any changes, for example if any children are born or if there are any significant changes to the financial circumstances after the agreement has been signed. By obtaining specialist legal advice, you are taking the necessary steps to ensure that any agreement you enter into carries more weight in subsequent divorce or dissolution proceedings. A solicitor can advise you on the terms of the agreement, whether they are fair, and whether they are likely to be upheld by a court. If your spouse suggests that they would like to enter into an agreement, it is vital that you get independent advice on the fairness. Using the correct processes from the outset will save a lot of heartache and stress, as well as costs in the long run in any subsequent divorce and dissolution proceedings. In the event that you are already married or in a civil partnership, you may wish to consider a post-nuptial agreement. This works on the same principles as a prenuptial or pre-civil partnership agreement, but is entered into post-marriage or civil partnership. In the event that you do have a prenuptial or pre-civil partnership agreement, it may also be worth you revisiting it to consider any significant changes that have taken place since the agreement was signed. It can actually give the agreement further weight if you are able to show that there has been ongoing joint consideration about the fairness and appropriateness of the agreement pursuant to any changes in circumstances.